for my clients and in particular. So business owners have a very specific type of or sort of set of considerations that they need to be aware of on top of what maybe just a normal, I guess, quote unquote, normal individual coming in for their estate plan would have to think about. There's a lot of other considerations as well. And a lot of what you need to do depends not only on the type of business you run or the structure of that business, but also how many people own that business and maybe what sorts of restrictions in terms of ownership that business may have, or whether through law because of something like a doctor's office or a law firm, or through the ownership structure set up in the documents themselves, the business documents. So there's a lot of things you have to keep in mind, and it generally takes a lot more involved planning than somebody who doesn't own a business, just because of all of those considerations that you need to have. So that's our topic today, and we're primarily going to be focusing on that. And then next week we have our what to do if a loved one needs care soon, which is going to talk a lot more about long-term care planning and preparing to pay for long-term care, as well as what to do if you're concerned about not having enough to pay for long-term care. So that's our upcoming topic next week. So I will touch a little bit on it today with the business side of things, some things you need to be aware of as a business owner when it comes to long-term care, but won't go too in depth into it so as to not take too much away from next week's either. But welcome everybody. I'm attorney Justin Randall with Hooper Law Office. Today I'm going to be talking about business succession planning or business exit planning in relation to someone's estate plan. A lot of people think of them as very separate things. I have my estate plan for me and then planning for the business separately, but they're very interrelated, and they need to work well together, because if you do not have your estate plan and your business plan actually mesh well, or if they conflict in any way, that can create a lot of issues for your family, for the business, for the other owners of the business. I mean, kind of across the board. It really makes it much more difficult to deal with after one of the owners has potentially passed or become disabled. So that is going to be our big primary topic today. One thing, or a couple things I should say before I go too in detail. If you are participating via Zoom, you will be able to ask questions through the Q&A chat function. I will be able to see them come up, and I'll be happy to answer them as they come in to the best of my ability in that moment. But otherwise, if you are not participating via Zoom, you won't be able to do that. So if you're on Facebook or Facebook Live or YouTube, you won't be able to see that. And at the end of this webinar, if you did sign up in advance, you will receive an email from us that if any of the things we talked about today make you want to come in for a consultation to talk through your own situation, that will give you a place to give some feedback for the presentation, as well as a place to sign up for initial consultation. Those are complimentary. Don't cost our clients, or our prospective clients, I should say, anything to come in and talk with us. And they're also usually set around for 2 hours, I would say. Business planning, if that's what somebody is coming in for succession planning in relation to their estate plan, that maybe end up being a little longer, or multiple meetings, just because of how involved it can be, and how many people tend to be involved in it. So so if anything raises any of those concerns today, please feel free to let us know or reach out with questions. Okay, to get started, kind of with business planning and estate planning, as I mentioned, they relate together so much because of the way that people often pass on their businesses. Inevitably, if someone passes away, whatever their estate plan says is going to impact what they own. And that can involve shares in a business, stocks of a corporation, or just if it's a sole proprietorship, the assets of that business, partnerships as well, shares of a partnership. So those are controlled a lot of times by someone's estate plan, especially if they haven't done any sort of prospective business succession planning. So there are things that you need to be aware of as a business owner, especially if you own with multiple people in particular, that you need to look at through the business side of things, but also make sure that, hey, okay, when I look at what happens when I pass, how's my family impacted? What sorts of restrictions are there on the business ownership and all of that? So to give you a kind of idea of, the more standard types of businesses that somebody might own, right? We're talking sole proprietorship as somebody is I own the business myself. I'm not doing it through any sort of entity. I am just running the business as me. That is a pretty common one that people will use, especially if they haven't, thought to do any business planning. Partnerships are a very common one as well, but really I would say probably the two most common we see these days are LLCs. People have a lot of LLCs and corporations, whether it's a C corporation or an S corporation. And an S corporation is really just an election you make through the IRS to say, I am a small business corporation. I'm taking that pass-through income to myself, kind of like you would with an LLC or a partnership or just as a sole proprietor. So really though, the big thing with, business entities in particular that a lot of people either aren't aware of, or it's been a really long time since they've taken a look at it, is what are your governing documents for the business? So when it comes to LLCs, to give you a good example, a lot of people with LLCs think, I have my operating agreement, here it is. And when it's presented to me, what it really is it's the articles of organization. What the articles of organization are, anybody can go, file for an LLC, you get your articles of organization. That just says, I have this LLC, I'm I'm the member or the manager of the LLC. Here's, any tax information that I might have had set up, like a taxpayer ID, and here's the filing, that I've made for that LLC name. It's not actually an operating agreement. So an operating agreement is really the governing rules of your LLC or your entity. The state of Wisconsin and a lot of states have like an LLC statute chapter where those sort of act as your default operating agreement if you have not custom drafted one. But the problem with so if you've just filed an article of the articles of organization, have received them, that's primarily what most people tend to use is that default statutory like guideline operating agreement. And it's really not ideal for a lot of people because with LLCs in particular, you need to be aware of the liability protection that you're supposed to be receiving from an LLC. And if somebody has an operating agreement or is using the default rules, and they in any way are not following those rules well, or are, actively or consistently sort of just disregarding them, that can ruin the liability protection for the business owner, because they are essentially just violating their own operating agreement. So by setting up a custom operating agreement for an LLC, you're really making sure that, sort of I'm setting my own rules, and I have a really easy place to go look at them and figure out if, based on the rules I agreed, to set in place, or myself and another business owner agreed to set in place, here's what we can and can't do. Here's the type of restrictions we can place on who can be an owner. Here's where we define different roles in the business, all sorts of things. So it's really kind of that's a non-exhaustive list by, any standard. There's plenty of things you can plan through with an operating agreement. Another thing that a lot of business owners don't think about is having some sort of restriction on transfers or triggering events, they're often called, where, okay, so if I were disabled or I passed away unexpectedly, where do my shares go of that business? Who can be an owner of this business? What happens if, a sort of non-authorized owner, is the recipient of those shares temporarily? What does the purchase price look like? How is that valued? You really need to have, for any sort of succession plan or disability plan for a business, both an operating agreement for an LLC anyway, or governing documents in general that you have intentionally set up, along with a good, consistently, well drafted buy-sell agreement where you've set those purchase terms, you've set the restrictions on ownership, so you can really control what happens to your business after you're gone. This is really, really important, as I mentioned earlier, with multiple owners, because, if you're owning a business with a couple other people or just one other person, and you're not from the same family, you're not siblings, for example, maybe you don't want to own it with your business partner spouse or their children, or they don't want to own it with yours, or you don't want it to just go to some random person, right? So it's really important then that you and the other owners, especially, if there's one or more multiple owners with you, that you sit down and you discuss, okay, what does this look like for our business? What restrictions do we want to place going forward, so that we can make sure that, if our intention is to keep this business running, if something happens to one or more of us, how do we make sure that that happens? How do we put these people in the right position? And how do we make sure that we're not owning it with maybe people we don't want to be owners, or who are just not the right people to be owners? And that doesn't mean through those terms that you're not having your family potentially benefit still from the value of what your ownership interest was. It just means that rather than being owners, maybe the buy-sell agreement requires that the company purchase, buy out the recipient of those shares or stocks, depending on how the company is set up. So those are really important documents to have in place, not only for disability planning, or death planning, but yeah, long-term disability is a really big concern for a lot of business owners. So those triggering events, kind of what would force someone to potentially, need to be bought out, or for a company to buy out that person, their interest. A common one is obviously death, right? If I pass away, where do my shares go, and who can be an owner? Retirement is one, although whether retirement is a triggering event, like if I stop being an employee and I'm just going home and never gonna, work in the business anymore, whether that's a triggering event depends a lot on, the other owners, kind of what the business is. Is it really essential to buy out the person on retirement? It really depends on the individual. So that one's a little more situational, I would say. But another key one I mentioned is disability, long-term disability in particular. You really want to define for a business owner what that long-term disability looks like. How long do they need to be disabled before the company has a right to purchase their shares, or before they're required to sell back to the company? This becomes really important, especially when you're looking at potentially like if there are any sort of long-term care concerns for somebody and they're a business owner. It's not so much to protect the value of their shares from long-term care. They're still going to be paid out directly, in that buy-sell agreement to that individual, but they'll have to pay for their care with those proceeds. But it's to protect the other business owners from that long-term care liability. So if somebody ends up potentially owning these shares, and that's an asset of theirs, well, that could either prevent them from ever receiving, Medicaid assistance if they're just holding on to them. It could mean that potentially there's a chance that some sort of lien will be placed on it if there's any creditor concerns for, other than just long-term liability or long-term care, I should say. Those sorts of triggering events are really important to plan for, so as to make sure that not just you as one owner are protected, but the other owners and the business itself will survive that happening to somebody. This can be a lot harder, obviously, though, when the business kind of is one of the owners, like it just wouldn't exist without them. That's harder to plan for, but there are still things you can do through succession planning to account for that as well. Primarily, when we're talking about succession planning, it really kind of breaks down into two sort of main areas, right? Planning for your business. Succession planning covers disability planning and sort of unexpected death. So who can take care of the business for me, or who owns the business after I'm gone. But it also includes picking the right people to replace you as owner as well. Succession planning is not okay, we get these documents in place and we're done, right? It's really an ongoing process for many, many years. I mean, a good succession plan, in order to fully be complete, it's going to happen over a period of 5 to 10 years, right? You're not looking at, okay, I'm picking my successor and I'm out. A good succession plan will be, I have identified the people who will replace me. I've made sure they're the right fit. I've sort of brought them up to speed with what ownership looks like. I've groomed them, so to speak, to replace me. And that is so important to any good succession plan that has been done. And that's less so necessarily on the actual legal documentation side of it, potentially, but also just on you as the owner picking that right person. You're going to be the one that knows best who should replace me. feel the most comfortable with that. One thing to keep in mind when you're looking at, picking successors and all of that is working with that, your successor, of what do they think ownership looks like? What is their timeline on things? Because it really is not just what you want anymore at that point. You're also working with another individual who has their own goals and desires and all of that. So you really need to talk with them and say, okay, what is your timeline for becoming an owner? Does it look like I slowly transition ownership to you, or is it all at once at one period of time? What does that look like? Succession planning happens a lot with family-owned businesses, but it doesn't need to, right? It can be any business has good succession planning. It just really means that you're looking for somebody and you're setting them up for success to succeed you and continue running that business after you're gone. And then one of the other sort of sub areas of, I guess it's kind of its own separate area in some ways, but also very related to this, is business exit planning, right? And exit planning you can think of more as, okay, I don't really, I'm not looking for anyone to succeed me. I'm just trying to, maximize the value of this business, sell the business to somebody and get out. And that involves some of the same planning mechanisms that succession planning does. Like, you still want to obviously have a really good, governing document for the business and operating agreement. You want to potentially still have probably still have a buy-sell agreement, just if something happened in the interim for disability's sake. But you're looking more at that point of maximizing the value of everything so that you can sell for the best price, right? Whereas with succession planning, you might be looking at, not forcing the person who's buying you out to, necessarily have to pay the most possible, because that might not, be the best plan going forward in terms of what works for their finances as well. Doesn't mean you shouldn't be adequately compensated for your shares. It just means you have to take more complex valuations into account. So when, that's the business side of things. But as I mentioned, they play very heavily into what happens with your estate plan as well. And this is something a lot of people don't think about, unfortunately, with their business documents. They think, oh, I have, this'll, it'll be fine, it'll all work out. But if your business documents say something that, it restricts ownership, for example, to a certain group of people, and it can't go to spouses, you want to make sure you take a look at your will or your trust, whatever your estate plan is, and see how that works with that sort of business succession side of things. Are you specifically leaving a business to a spouse in your will or your trust? Are you leaving it to people who are not allowed to own it potentially? And that can really impact just how well they work together. I mean, it doesn't mean that there wouldn't be some resolution at some point, but it would make it more expensive to come to that resolution. It would make it more complex and not as smooth of a transfer. And I mean, the really big thing with estate plans and business plans together is not just what happens at death, but also what happens, as I've mentioned a couple times now, with a disability, right? What are you allowed to do as a business owner if you're disabled through your business documents? Who are you naming as sort of your financial powers of attorney, your trustees, if you're disabled, and who is going to be able to step in and manage things for you on both sides? It might be that you have named, the right person through your financial power of attorney who is also a business owner with you, especially if it's a family-owned business, right? That might be more common. But a lot of business owners should also think about potentially having sort of a limited financial power of attorney for that business alone, so that the other business owner can act as their representative for that business matter too. So the estate planning side of things plays into that business succession planning, because if they are completely conflicting, that's going to lead to problems. And as I said, especially with estate planning, the goal of estate planning primarily is to make sure that your beneficiaries receive what you want them to, or the value at least of what you owned when you passed away. So you can make sure then that with that buy-sell agreement, or like a stock purchase agreement, or any sort of buyout from a business at someone's death, that is going to the right place through that estate plan, or that the people are still receiving the value of that business. It gets a lot more complex as a business succession plan the more owners you have. It always will, because you need more people to agree on those terms, right? going forward. And so, I mean, that's why it can be a very long, drawn out process, but it doesn't mean it's an unnecessary process. It's a very important thing to go through. Things can change. Business succession plans can change. Just like if you're a client of our office or if you've heard any of our seminars before, you'll know that estate plans need regular reviews, right? And business plans are no different. They also need regular reviews. You need to make sure that, hey, if a law has changed, we're incorporating this into our plan. If if our situation has changed, our owners have moved on, or vice versa, and something along those lines has changed, that we can also incorporate those as well. One of the most important things to keep in mind when you're looking at buying out a business or having a buy-sell agreement and that succession is how best to fund that. And by fund it, I mean how is the purchaser going to buy the shares of the deceased owner or the disabled owner or the retired owner, depending on that triggering event. A very common tool used is life insurance. So if you are insurable through life insurance, and of course not everyone is for health reasons, but if you are, you want to make sure that maybe you or the business has a policy taken out on the life of an owner, so that if you need to suddenly buy out the other owner's family from the company, as accordance with the buy-sell agreement, that you have the right right process set up in terms of funding it. I mean, if somebody's share in a business was worth $1 million, for example, I would be willing to bet not a ton of people have just $1 million on hand to pay out the other family. So that's where you make sure that, okay, I have life insurance or some sort of process set up in which this buy-sell agreement is not just set up to fail. So that's the funding side of it. And it's really essential to make sure that that is, actually set up realistically for somebody. I had one example, I think one time I had read where somebody had tried to set up a buy-sell agreement that took place over it was decades, right? I mean, it was a long period of time. And at that point, the buy-sell agreement doesn't do the other owners really any good, or the family of that deceased owner any good, because by the time they're paid out, the other owners might have passed away too. I mean, you think about the age at which someone passes away. If you're doing like a 40-year buyout, I mean, by that point, all the other owners are probably passed away too. So it's just something to keep in mind. When you're looking at business succession planning and making sure that the business is set up for success for the next owner too, especially on the succession side of things, not so much as much the exit side of things. You want to look at making sure you're keeping really, really good, accurate, annual records on things. A lot of businesses have to keep take annual meetings and have a record of those annual meeting minutes and what was talked about, what was decided, keep a record of all of your up-to-date, I've re-registered my LLC or paid the annual fee for it. Those sorts of things are really important to keep accurate records for, because you want to make sure that if somebody ever looked at, how has this business been run? I mean, the future owners, when they buy into that company, you don't want them to be responsible for some sort of breach of liability protection that happened in the past. So it's really important to make sure you have those accurate records going forward to make sure that the new owners are also comfortable assuming control of that business and are not going to be taking on any liability that they weren't anticipating, as much as you can control that. I mean, obviously, you can't ever stop anyone from ever getting sued. It's, people can sue for any reason. It doesn't mean they'll win. It just means that somebody can file a lawsuit for any reason. So it's just those annual records, though, are very important to keep accurate records and make sure you're following all the reporting requirements on those businesses in order to set up the next owner or generation of owners for the best they possibly can be for success. Obviously, it's still important even with exit planning for your own liability concerns, but if you're just selling the assets of the business, that's a little different. So one quick thing I wanted to talk about with business owners, and I mentioned I was going to talk a little bit about the long-term care side of this today. The really big thing that you need to be aware of as a business owner for long-term care is whether or not the business itself is a countable asset for if you need Medicaid assistance. So with Medicaid, they have countable and unavailable, or countable and not countable assets. So by that I mean what they say, how they calculate your net worth for terms of receiving Medicaid benefits, and are you over the asset limitations. A business generally is not a countable asset if it is if it's involved in an active trade or business, like it's actually doing business right now. If it was at one point, and this was an example I had heard actually, I think at a conference, but it was at one point a bar, and now it was just real estate, but they weren't actually running it as a bar anymore. That's not an active trade or business, right? So then the assets of that business would be a countable asset, or the value of that business, that owner's share in the business, would be counted against them for Medicaid qualification for long-term care. So, if it is an active trade or business, that does not mean that the actual, business itself is a countable asset. Now, of course, any income coming from it would be. That's still income to that individual, and they're still entitled to their share of income. You can't just shut off that income if they are still an owner. And that is where it's really important, though, to look at having the right triggering events in the buy-sell agreement for a business. Because if that happens, and that person would almost certainly meet any definition of long-term disability, unless it was, a completely unrealistic definition that the buy-sell agreement had used. Long-term care is almost certainly going to qualify for that as a triggering event. So that would provide at least the business a way to say, all right, we're just not even going to worry about this. We have the right to purchase these shares or their percentage of ownership. The family or the individual is still going to be receiving the value of those shares, but the business itself becomes insulated from that sort of obligation of that individual and ever becoming accountable for that purpose. So, even if something happened in the business, just stopped operating as an active business, right? So it's something that business owners in particular need to be aware of, and they need to think about, because a lot of times businesses can be worth a fair amount of money, right? I mean, plenty of businesses are valued in the millions of dollars, but that doesn't mean that any individual owner has a multi-million-dollar estate just available to pay for long-term care. So you want to make sure, though, that if they're going to be over any countable assets if it's not an active trade or business, that you provide for a way for them to get out and be compensated fairly for it, so that it insulates the business and gives that owner their fair share of the business as well. When it comes to some things in particular, when you're looking at making sure that a business is run properly, like an LLC, for example, so that you're keeping that liability protection, it's really important, for example, to keep the assets separate from that business that are your personal assets. So that's where an estate plan can deal perfectly with, I have my personal home, my bank account that I use for myself, my retirement accounts, my investment accounts, all of that. But I would never use my personal bank account if I was an LLC owner, not for the purpose of that LLC. I wouldn't have payments made out directly to me. And that's something that a lot of people unfortunately aren't aware of. They especially with LLCs, if it's a kind of a single member LLC or just a family owned LLC, and they're not really they haven't done a lot of business planning in the past, they'll have just a bank account that they put all of their money in, and it's their personal bank account, and they don't really make it clear to the people they're working with through that business in terms of customers and other contractors and all of that LLC is its own entity. People can pierce that liability protection of an LLC if it's made to appear that it's no different than the individual owners. If they see directly to those people, because they're paying, making payments out directly to those owners rather than to the LLC itself, or because they're using personal bank accounts as the LLC bank account, or if they're using the LLC for personal expenses. I mean, all sorts of things can sort of commingle it like you would almost with like marital assets if you have like a marital property agreement, right? But it's more so to make sure that your own personal assets are protected from the liabilities of that business. And that's a really big misconception as well that a lot of people have with LLCs, I would say. Kind of a side note is LLCs do not protect generally what is in the LLC from liability, so much as they protect the owner's assets that are their own individual assets from the liability of the LLC. So if I was, if a law firm is an LLC and they're committing, just egregious malpractice and they get sued, right? The LLC may be liable for that, or if they're committing fraud, or if like a bank is committing fraud, or any sort of example you can come up with where it's the business doing, being liable for something rather than the individual owners. You want to make sure that they can't then look through to the individual owners and what they call piercing the veil of protection. So that is where keeping things separate is essential to business owners from their personal assets to the business assets. So just a couple minutes left here, and just one quick reminder, please, if you get that evaluation form from us, please feel free to fill it out and, talk about any topics you'd like us to discuss. I mean, we're always looking for new ideas on various topics. And if you want to set up a time to talk with, we have a business succession team here at our firm. It involves myself, Sarah Kahns, one of the partners at our firm, and Kimberly Eichhorn, one of our paralegals. So we really do a team effort, a team approach here to our business succession planning, and it really requires it because there's a lot of involvement. But so if you would like to set something up for yourself as a business owner, or you and your other business partners for that type of discussion, I'd be happy to sit down with you, and Sarah would as well, I'm sure, to sit down with you and we can have a meeting about what that future kind of looks like for the business, because it really is an individualized approach. No business plan is going to work the same for every business. So please feel long-winded. I'm sorry. Please feel free to fill that out, and we'll set up a time to discuss with you. Again, those are complimentary consultations. We don't charge our clients for meetings, if especially for reviews or anything like that either. So if we need to make changes to a plan, obviously that's a little different. But the meetings themselves, it's really important that you feel free to come in and talk to us to get the right information. So please feel free to fill that out. Again, you'll be receiving kind of our quick little cheat sheet on the types of business and like how they protect from liability or don't. And also, if you were one of the first 50 registrants, I believe Nicole had told me that you are going to receive our business, estate planning book #2, where it talks a little bit about business planning and everything else kind of associated with how that works with estate planning. So thank you so much, everybody, for joining me. I know, business planning is a complex topic, and 30 minutes isn't necessarily enough to really go too deep into it, but hopefully I at least scratched the surface for you a little bit about the things you need to be aware of and the types of things you need in place. Again, if you guys have any questions, please feel free to set up that initial consultation, or you can reach out to any of us here at our office, and we'd be happy to set something up.